Thank you for joining us tonight, and welcome to the Northwest Consumer Law Center webinar series, How to Survive the Financial Impacts of COVID-19. Today's webinar is Landlord Tenant Law and COVID-19, an update on Washington's eviction moratorium and options for renters. Today, my name is Amanda Martin, and I'm the Executive Director of the Northwest Consumer Law Center. Today, we have Northwest Consumer Law Center board member Brendan Donckers with us, who will be discussing the options for tenants financially struggling due to COVID-19. If you have questions during the presentation, please enter those in the chat box on your right. We will be answering questions after Brendan's presentation. This session is being recorded and will be available online at our website. Attending this webinar does not create an attorney-client relationship. This presentation provides legal information and is not a substitute for individualized legal advice. If you're seeking legal assistance, you're welcome to contact the Northwest Consumer Law Center after this session. We will provide our contact information at the end of this webinar. And with that, I'm going to hand this over to Brendan.
Okay, thanks, Amanda. With the fear and stress that comes with a sudden and unexpected loss of income, it can be difficult to understand your rights, know how to exercise those, and find resources that are available to help you. So if you're renting an apartment or a home right now, we want to help you keep it. And tonight we're going to talk a little bit about the legal framework for landlord-tenant laws and how an eviction happens, and also provide some resources that are available for you towards the end. As Amanda said, my name is Brendan, and I'm a civil rights and consumer protection attorney in Seattle. And as she also said, I'm a lawyer, but I'm not your lawyer. So if you have specific questions to a specific case, we want to help you find a lawyer so that a lawyer can help you through this challenging time. If you're renting a home or an apartment, you probably signed a lease. Now, you don't have to have a lease to have a landlord-tenant relationship in Washington, but in most cases, folks have signed leases, and you should get it. If you don't have a copy of your lease, you should ask your landlord for one. The landlord was supposed to give you one at the onset of the tenant relationship, and if you've lost it, the landlord-tenant laws allow you to a replacement copy. So you should get a hold of your lease. You signed it, you should know what you signed, and when you talk to a lawyer, it'll be one of the first things a lawyer asks for. And your lease is just one part of the legal framework governing a tenancy in Washington. There are also state laws, there are city laws, and there may be county laws that apply as well. I'm going to focus on the state law, but you should be aware that if you live within a city, the city, there may be a city code that provides greater protections for you. For instance, the city of Seattle has a just cause ordinance that provides greater protection to renters in the Seattle area. If you don't live in a city, but you live in an unincorporated county, the county may also have some rules that apply. So you should be aware that it's not only your lease and the landlord tenant state laws, but there may also be a local ordinance for you to review. In Washington, there's our state's Landlord Tenant Act. The Residential Landlord Tenant Act, or the RLTA, is codified in Washington law, or Revised Code of Washington, or the RCW, and you can access the RCW online. You can just Google if you want 59.18 RCW. You do that, and the Landlord Tenant Act will pop up. I think I can share that with you here. So I'm gonna try this for a second and see if this works out. So hopefully you can see that. And you can just see the website there. It's app.ledge.wa.gov /RCW. And but if you Google 5918, this will pop up, and I'll go back to this in a few minutes. Okay. So within 5918, you can see a series of subjects that apply to the landlord-tenant relationship. I'm going to get into a few of these, a few specific areas. But remember that the RLTA applies along with your lease. So the RLTA sets a baseline of protections that are available to you as a tenant, regardless of whether the landlord mentions those in the lease. So for instance, a landlord cannot relieve himself or herself of the duty to provide you with a roof that works, or the landlord cannot relieve himself or herself of the duty of providing electricity that works. These are in the Landlord-Tenant Act, and these are some of the basic duties that a landlord has to make sure that you're provided with in the tenancy. You should also know that the there's a Mobile Home Landlord-Tenant Act. So if you live in a mobile home, it's not 5918 that's going to govern your relationship with the landlord along with the lease. It's going to be 5920, and 5920 has a lot of the duties that are set out that the Residential Landlord-Tenant Act has. So you want to be aware of the NHLTA that's under 5920 if you have a mobile home that you're renting. So the RCW, your lease, are the two key areas that govern your relationship with your landlord. It's worth you taking a look at both your lease, as I mentioned, and the RLTA as you're starting to consider whether there's going to be a dispute with your landlord. Knowledge is empowering, and while you may need a landlord to help you resolve some of these issues, it's good to start understanding what the framework is, even if some of the RLTA and MHLTA are written in legalese. So let's talk about eviction. You've lost your job, or there's a medical emergency, sudden loss of income, with everything else in terms of the onslaught of bills and other obligations. You may be wondering whether you can afford rent next month, this month. Should you pay? The short answer is yes, you should do everything you can to keep your rent current. Non-payment of rent is the most common way that someone may lose their lease and be evicted in Washington. And Washington law, like many states, give landlords extraordinary power to move through the eviction process if you haven't paid your rent. So if you can try to keep your rent current, by all means possible. Now, in response to COVID-19, there have been several moratoriums that have been put into place. The governor of the state of Washington has imposed a moratorium. I believe it's a 30-day moratorium that started on March 17th, and it goes until mid-April, April 17th. Some cities have also taken action in the state of Washington. Cities have provided protections beyond what the governor's moratorium is. The city of Seattle has imposed a 60-day moratorium. I heard that the city council may be looking to extend that further. The city of Spokane has a moratorium through April. And these moratoriums basically provide protections from eviction while the moratoriums are in place. They do not relieve you of the obligation to pay rent. So simply because these moratoriums are in place does not mean that you can avoid paying rent. You just cannot be evicted for not paying rent while the moratorium is in place. Now, there's also a federal moratorium that's in place. I believe that was put into effect with the federal stimulus plan last Friday, March 27th, and it's a 120-day moratorium. It applies to properties that are covered under the Violence Against Women Act, which includes Section 8 housing. It applies to mortgages that have that are federally backed by Fannie or Freddie, or mortgages that are federally insured. Now, this covers a large percentage of properties that are subject to mortgages or VOWA protection, but it may not be that easy to find out if the property that you're renting is covered. Some land records may not have all of this information that's accessible. Your best bet, at least for now, is to try and contact Fannie or Freddie. You may get a rep that will be able to help you. I'll provide some resources at the end of this that can talk a little bit more about where there are resources for you on that. So as I said, these moratoriums, the state, city, and federal, don't relieve you of the obligation to pay rent. They can limit the ability of a landlord to evict you while the moratoriums are in place. Once the moratoriums are lifted, we should expect landlords to go back into the business of evicting folks that don't pay rent. So there could be a large, if the moratoriums continue, there's multi-months, you should try to save up so that you can keep your rent current, because there's no reason to think that landlords won't try to use the procedures under the law to quickly evict folks when the moratoriums are lifted. Not everyone can afford to continue to pay their rent. So what happens? The first step in the eviction process is that the landlord will usually serve a pay or vacate notice. The pay or vacate notice, if it's an issue of non-payment, is usually 14 days. You'll have 14 days to pay or vacate, and then the landlord will move forward with eviction. But you may also get a notice to comply or vacate, which could apply to other provisions in the lease. You don't have a dog, you're not allowed to have a dog, but you have a dog. The land says remove the dog in 10 days or we're going to evict you. So the initial step in the eviction process is starting with one of these notices to pay or comply within a certain period of time. If the amount that's owed is not paid in that period of time, the landlord will be entitled to start the eviction process by filing and serving a summons and complaint on you. And the summons and complaint are two separate documents. They both need to be filed in the court and served on you to effectuate the formal starting of an eviction lawsuit. One thing to keep in mind is that the landlord has to go through the eviction process that includes filing a summons and complaint to be able to evict. There is no self-help in Washington. That means a landlord cannot tell you if you do not pay that he or she is going to remove you from the property themselves. They have to get an order from the court to be able to do that. And even when a landlord gets that order, the landlord cannot effectuate that. Yet he or she has to rely on law enforcement to be able to do that. So know that serving the summons and complaint is only the first step in the legal process. The landlord cannot come out to forcibly remove you from the property. They can't shut your utilities off if you don't pay rent. They can't lock you out without a court order. The landlord has to use the legal means that are available to him or her, which is starting with a summons and a complaint. Now, the summons and complaint, it's filed in the court, and the summons is and the complaint are served on you. They can be served on you personally. That means you have to be there to accept service of the summons and complaint. If you're not there, someone else in your home can accept service of the summons and complaint. But if it's not you and someone else does, they have to also mail the summons and complaint to you. Now, if you're not home, the landlord has to go through another process that can then allow him or her to post the notice to your door and then follow that, that the summons and post the summons and complaint to your door and then also mail that to you. Once the complaint is effectively served, again, served either by mailing and posting or serving you personally or serving someone else, followed by a mail, the summons will tell you how much time you have to respond to the complaint. It may be very quick. You may have just 7 days to answer the complaint. But you should pay attention to what the summons says in terms of the time to respond. The time that the summons says may or may not be correct, and you may need to engage a lawyer to help you understand whether the landlord is correct in saying you have to respond in the period set out in the summons. but it is the safest bet until you get a lawyer to respond in that time frame. A timely response is important. If you don't timely respond to a complaint that is served against you, the landlord can seek a default against you. And a default makes it very difficult to defend yourself if a default is entered against you. So you should try to answer the complaint on time. And don't think that by avoiding answering the complaint that you're going to be able to prevent the landlord from moving forward with an eviction. The landlord can try to move forward, a default against you, and continue the process. So answering the complaint is very important. Answering the complaint is important because it is the first opportunity that you have to set out your story, your narrative. What happened? Why is the rent that the landlord is trying to seek from you not owed? It's a good practice if you can find a lawyer when you receive a summons and complaint, to try and find a lawyer at that time. If you cannot find a lawyer by the time you have to answer, you should try to answer yourself. And I'll talk about some of the resources that are available to help you do that. But don't let the time go by for answering. After you've answered the complaint, you will usually, the landlord can move for what's called a show cause hearing. And the show cause hearing is called that because you are required as a tenant to go and show cause why the landlord shouldn't evict you, why the landlord doesn't have a right to get his or her property back. Now, you have a constitutional right to a hearing before anything can be taken from you. The show cause hearing in the context of the Landlord-Tenant Act may be it. So it's important to be mindful and watching service of other documents after you've answered, because you will get notice of the show cause hearing as long as you've answered. At the show cause hearing, the landlord is going to ask for what's called a writ of restitution that entitles the landlord to get the property back. Now, before you get to the show cause hearing, there's a hurdle that landlords sometimes try to create for tenants, and that's called the 375 notice. And it's because in 5918.375, the landlord can put you through a hoop to either put money into the court's registry, the total amount that the landlord says is owed for rent, or the landlord or the landlord will require you to swear under penalty of perjury that you don't owe the amount that the landlord is saying you owe. This 59.18.375 can be used to try and avoid a show cause hearing. So it's very important, like the answer, if you get served with a 59.18.375 notice, that you answer that document as well. So hopefully you don't receive a 375, or if you do, you've answered it and you proceed to the show cause hearing. The time between receiving the complaint and answering and then the show cause hearing can be very quick. It can be a couple weeks from the time that you answer. So this can be a very, as I said at the outset, very quick process designed to give landlords a chance to have their property back quickly. So you have to pay attention to these notices that you're receiving in the mail. At the show cause hearing, there's a very narrow set of issues that the court is going to be asked to look at, and that really boils down to whether the landlord has the right to getting the property back. And in your answer, you may be disputing that the amount of rent the landlord is seeking is correct. That's appropriate to raise and fight about at the show cause hearing. The landlord may be charging a bunch of extra fees that aren't legal. Appropriate thing to be fighting about at the show cause hearing. If you show up at the show cause hearing and you are fighting about the amount of money, it may not be a total defense to eviction. What may happen is that because there's a dispute about the amount owed, the judge is going to set the case for trial. So, that will be another hearing or another procedure that you'll have to go through where evidence will be presented and either a judge or a jury will be making a decision. So show cause hearing, it's an opportunity to dispute the amount of rent that's owed. Now, another thing that you can ask for at the show cause hearing and raise in your answer is you can ask the judge or the commissioner to consider a payment plan. Now, the Residential Landlord Tenant Act also allows tenants to ask for time to pay their rent. And this is under 5918.410. This is a right to ask the court to stay the eviction because there are circumstances that made paying the rent hard for you. You may be, have just lost your job. It may be a one-time issue, a medical emergency. You may have a great history of paying your rent on time, and this was just a sudden problem. Show cause hearing is a time where you can ask the court enter a stay on the eviction, so you have an opportunity to get your rent caught up over a longer period. Now, the right to a stay is a limited right. In other words, it's discretionary. So it doesn't mean that if you ask for it, you will get it. You have to show up at the show cause hearing and pitch your case to the judge. Your Honor, this is why I'm entitled to get this stay and time. And the factors are outlined in 5918.410. You should look at those. But the court is going to look at things like payment history, the reason you can't pay, and the hardship if you're evicted. So aside from the disputing the amount owed or requesting a payment plan, there's a couple other issues that you may want to consider raising. I don't have a ton of time to go through these, but I do want to raise these so you can bring these up in the context of your meeting with an attorney when you get to that point. So there are procedural rights that you have and there are substantive rights that you have. Some of the procedural rights that you have that you want to raise at the show cause hearing can basically check the landlord to make sure he or she is following the right process. For instance, procedural rights. Did the landlord serve you? Maybe the landlord just mailed the complaint and summons you. You want to raise that in the defense and force the landlord to start over because the landlord has to follow the correct process. The landlord may not have named the right parties in the complaint. These are procedural defenses that you can raise that the landlord didn't do something correctly in filing the lawsuit. Now, this doesn't mean that you will be able to prevent the landlord from ever evicting you. It may just slow the landlord up. So there may be procedural issues you can raise. Now, there are also substantive rights that you have as anyone in the state of Washington does. Civil rights, for instance, the right to be free from discrimination. You may have a disability. Your disability may have complicated your ability to earn income. Your disability may be the reason that your landlord is refusing to negotiate some additional time to pay. If you've asked the landlord, you'd like an accommodation, you'd like time to pay, the landlord ignores your request for an accommodation, you may have a claim under the disability laws that you would want to raise at the show cause hearing asking for a reasonable accommodation. Just like disabilities, you have a right to be free from discrimination for your race, for your religion, for your orientation. Now, these don't all necessarily qualify as defenses to eviction, but they could be. So you want to make sure that you raise these issues with a lawyer that you're talking to as you get ready for the show cause hearing. Lawyer or the landlord also cannot retaliate against you. The landlord cannot retaliate against you for complaining about mold or for complaining about other hazards. Cannot retaliate against you for asking something that is broken to be fixed. I mentioned the landlord's duties earlier. 5918.060 describes a bunch of duties that the landlord has relating largely to habitability, electricity, roof, water, heating. These are all duties that the landlord has, and they may be appropriate to raise in the context of a show cause hearing because the landlord's failure to fulfill some of these duties may be an offset that you can look at to try and reduce the amount of judgment that may be entered against you. It also may be that these issues have to be raised in a separate lawsuit. My advice usually to tenants is that if you can keep your rent current and fight about money another day after you've left the property, all the better when you're not worried about the cost of losing being a loss of your home. It's not always the case for everyone, but the law is set up in a way that it's not easy to raise all of these other issues at the show cause hearing. So you have to be aware of that and make sure you discuss that with the lawyer that you're talking to. If you lose at the show cause hearing, because the judge finds that you owe the rent, you don't have it, you still have an opportunity to save your tenants. Washington, the RLTA allows tenants to reinstate their lease up to 5 days after a writ of restitution has been entered. So you have to pay the full amount that is owed, that the landlord says is owed. And if you wait till after the show cause hearing and the writ is issued, you may also have to pay the landlord's costs. Filing fees could be late fees up to $75 and your landlord's attorney fees, and that can be significant. So your right to reinstatement isn't just after the show cause hearing. You can reinstate up until 5 days after the writ is issued. So it would be better to reinstate if you can find a friend or family member to help you with resources to reinstate the lease. You have that as a matter of right under the RLTA. The last point I will mention after the show cause hearing is what's called an order of limited dissemination. Now, a lot of folks, after they've been, a lawsuit has been filed against them, an eviction lawsuit has been filed against a tenant, how do I make it so that no one can see that? Well, in Washington, there's a strong right to access to public records and public documents. That includes lawsuits. You don't get to steal a lawsuit that has been filed against you without demonstrating extraordinary cause. I've been working with tenants on some of these issues for more than a decade, and I have not seen a court steal an eviction lawsuit. Doesn't mean it's impossible, it's just difficult. So what you can do is you can request either the landlord, negotiate with the landlord, or discuss or raise with the court an order of limited dissemination. This makes it hard to find out about an eviction lawsuit that may have been filed against you. It doesn't make it impossible. Someone can still go down to the courthouse, search your name, and find out about a lawsuit that may have been entered against you. But the order of limited dissemination makes it more difficult for third parties to find out about the lawsuit. Okay, so that is kind of a really quick rundown of some of the key issues you may see in an eviction action, a show cause hearing. There are a lot of resources out there that are available to help you in an increasing number, especially in response to COVID-19. One of the best resources that's out there, and I'll share this on my screen, is Washington Law Help. That's www.washingtonhelp.org. I'm going to share this screen here. There's information that tracks a lot of what I've said in the eviction context. There's a lot of information about what to expect in terms of issues that your landlord may raise that I'm not talking about. You can go down and see there's a specific link to COVID-19. You can see that there's eviction and tenants' rights. All of these have really important resources that are available for you to take a look at. To find a lawyer in Washington, again, I recommend that you go do some of this research on your own to find out a little bit about your own situation. But when you're ready to reach out to find a lawyer, if you're in King County, you can call 211. If you're outside of King County, there's the Clear line. That's CLEAR, Clear hotline, and it's 1-888-201-1014. It's open Monday through Friday from 9:15 to 12:15. Call in, and you may have to wait a little bit. There's high demand right now, but those are two really important resources. Again, 211 in King County, outside of King County, 1-888-201-1014, the Clear line. And there's also the housing justice projects around Washington. They're in a bunch of counties, including the most populous ones. King County has a housing justice project. I've been a volunteer there for more than 10 years. And there are also housing justice projects in Pierce County, in Thurston County, Snohomish County, Kitsap County, Skagit and Whatcom, Spokane County, Clark, Chelan Douglas, and Yakima. We'll get some information about how to contact the housing justice projects around Washington in those counties up on the Northwest Consumer Law Center's website. We'll also get some other resources up. I mentioned the Washington Law Help. We'll get that up on our webpage, the Northwest Consumer Law Center's webpage. We'll also get up information from the Tenants Union of Washington. They have some really excellent information for tenants, and that website is just tenantsunion.org. And they have information about moving in, moving out, eviction, termination, so information about discrimination and resources that are also available for you. I'll stop there. Thanks for listening. I think we'll do some questions now.
Brendan, we'll go ahead and open this up for questions. If you haven't entered your questions already, the chat box on the right, you can send those directly to Brendan and I. The first question I'll go ahead and handle is the webinar being recorded, and that is a yes. This will be put on the Northwest Consumer Law Center website, as well as our YouTube channel, so be sure to check there for updates. Brendan, the first question for you, if you live in an area with multiple landlord-tenant rules, such as state and local city regulations, how do you determine which set of rules apply?
Well, that's a good question. And under all circumstances, the State Residential Landlord-Tenant Act applies. Now, that's kind of the baseline framework for the landlord-tenant laws. The lease also applies, but if anything in the lease is inconsistent with the Residential Landlord-Tenant Act, it's invalid, right? The Residential Landlord-Tenant Act is a baseline of protections. In most cases, some of the city and county laws may provide additional protections. As I mentioned, there will, the city of Seattle has a just cause ordinance, which provides additional protections to tenants and limits how landlords can evict folks. Most of the local laws will provide more protections. You can Google Seattle Municipal Code, SMC, just cause ordinance or just cause eviction, and that language will come up to you. Now, not all of the cities necessarily will have greater protections. There may be some other rules that I don't want to get into speculating on or hypotheticals about, but for the most part, the Residential Landlord-Tenant Act is going to be your baseline. You can't do any worse as a tenant than what's provided in the RLTA.
A lot of service providers here today, and we have a question asking if you can say a little bit more about asking the court to stay in eviction because inability to pay, and how you can possibly get a payment plan with your landlord. Yeah,
and I'll direct you to the RLTA because it's written in section 410, 5918.410. It basically identifies the factors. So if you look at subsection, so 5918.410, you guys are folks that are service providers will understand 5918.410 subsection 3A lists the factors that the court is going to look at. And so I would try and make sure that you can fit your client's story, the tenant's story into those factors. And if it's related to the crisis that we're seeing now with COVID-19, I would hope that there's going to be a lot that the facts will fit compellingly into what those factors are. And I would hope that the judges are going to be sympathetic to folks that have encountered this scenario and have lost an income because of circumstances beyond their control. But look at the factors in 410.3 subsection 3 and fit your case into those. I would also make sure you raise that in the answer. You may be able to save a tenant the trouble of having to go to the show cause hearing if the landlord or the landlord's lawyer finds out, hey, this is someone that has representation. They get it. They know that I'm going to have a good chance of hearing my story. Let's save everyone the time and trouble. Take care of this tenant. Give us a little bit of time.
Is it legal to charge a late fee already on the third day after falling behind on rent instead of the fifth?
Yeah, legal fees are legal. Late fees are legal to charge. I don't, sitting here right now, have an answer on whether I don't have an answer, yes or no to that, and I'll tell you why. Because leases may I don't know if the RLTA prevents a lease from the landlord saying, "Hey, I'm going to charge late fees the day after you don't do a pay or vacate." You know, if it's 3 days or 5 days or 6 days. I don't, sitting here now, remember what the RLTA says about that. If the RLTA prohibits it, the landlord can't do it. I know late fees are prohibited. I just don't know the time period sitting here. I'm sorry.
A few more questions for you. Any idea what the eviction attorneys are doing now might potentially turn into Fair Debt Collection Practices Act issues in the future?
Will you read that again for me, Amanda? I'm sorry.
Any idea what the eviction attorneys are doing now may turn into Fair Debt Collection Practice Act issues?
I don't know what eviction lawyers are doing now. I presume that they're doing whatever they can to try and represent their clients' interests, which is to try and get their clients paid as soon as possible. How debt, the residential, so it would be a judgment that would be entered against a tenant, and how that debt squares with the FDCPA. The Northwest Consumer Law Center has board members and expertise that can talk to folks about consumer debt and how, underlying debt from a landlord may turn into a FDCPA claim. I just don't do enough FDCPA work to be able to give you clarity on that.
Yeah, I'll jump on that too. I would say that some of these debt collection issues arising from landlord-tenant debt collection turn into Fair Debt Collection Practice Act claims. So people who are being collected on for landlord-tenant debt should definitely talk to an attorney and see what their rights are. Another question we have for you is from somebody in Seattle who rents a daylight basement apartment in someone else's home. They have a month-to-month lease. Would landlord-tenant laws cover that situation?
Yes, absolutely.
And do you project that there will be a rent amnesty in the city of Seattle or King County or Washington State?
Well, I'm not sure. I'm not sure what you mean by rent amnesty. And I think that's important to make clear that the moratoriums are in place don't give tenants freedom from paying rent, right? Your rent is still due and it's still owed. The moratoriums just prevent landlords from filing, not even from obtaining a writ of restitution against a tenant while the moratoriums are in place. I'm not actually sure if the moratoriums prevent a landlord from filing the unlawful detainer action, but it's certainly a defense to proceed, going forward with the show cause hearing, getting a writ because these moratoriums are in place. I don't know if the city of Seattle is going to do anything outside of extending the moratorium. I know I've heard the council president has looked at maybe a 6-month moratorium, but the term like rent amnesty, I'm not aware of anything that could be construed as what rent amnesty might be.
Our last question in that. Thank you for this excellent presentation today.
Great. Thank you.
Thank you. And with that, please join us for other sessions in the Northwest Consumer Law Center webinar series, How to Survive the Financial Impacts of COVID-19, taking place every day this week at 6 p.m. Tomorrow, we will talk about foreclosure moratoriums and options for mortgage payments. Later this week, we'll be talking about student loans, debt collection, and bankruptcy. You can sign up for that online at nwclc.org/COVID-19. If you are seeking legal assistance for a consumer matter, I'm going to pull up our information so that way you can have that. There we go. And you're welcome to contact the Northwest Consumer Law Center for help. We're able to assist low and moderate income Washington residents with their consumer legal issues. You can apply online on our website at nwclc.org/get-help or by phone at 206-805-1722. You can also reach us at admin@nwclc.org. To support our work, you can make a contribution online at nwclc.org. Thank you everyone for joining us tonight, and take care.